out. Welcome everyone and good morning to all of you in person and watching online as recording. So this is Wednesday webinars with Payroll Centers for Women's Enterprise. Today we have a wonderful topic with a wonderful speaker coming in to share with us about strategic planning session. And so we have Deborah Meltzer. She is a trademark agent and lawyer at MBA Intellectual Property Law. So I'm just gonna give you the floor, Deborah, and for sure, take it on.
Yeah, thank you so much. So thanks guys for participating. This is really great. And hopefully I can provide some clarity on the basic intellectual property concepts. So I am a lawyer, trademark agent at MBM Intellectual Property Law. And my practice is focused on litigation primarily, but I'm also involved in a lot of contractual projects as well. So anything from employment agreements, licensing agreements in the context of IP, that's sort of what we do exclusively. So I'm really hoping to provide a brief overview. I work a lot with startups, entrepreneurs, and many people are in a position where they don't know what they need or the questions they should be asking. So I'm hoping to provide some insight. And if you guys have questions, let me know as we go along. So I'll just share my screen. Everyone can see it, I'm assuming. Yes. Yes. Okay, great. Okay, so what is intellectual property? So this is a question I get all the time. We often hear a lot of these terms wrongly used interchangeably. So what is a patent, trademark, copyright, trade secret, industrial design? A lot of people don't know what these terms mean, what exactly they protect, the different mechanisms you go about filing or registering one of these protections, and how you can actually employ a layered approach to incorporate patents and trademark, copyright, industrial design, whatever it is, to really maximize the protection for, let's say, a particular product or a concept or a brand. So we'll get into that a little bit just to sort of set the stage. So patents are the thing that protects an invention. And you have a limited monopoly. So you have 20 years from the date of filing that gives you exclusivity. So what it actually gives you is the right to exclude others from doing the thing that you claim. And the trade-off is sort of like, okay, we'll grant you a 20-year monopoly from the date of filing, but in exchange, you have to educate the public as to how to work your invention. And then after 20 years, it's everyone, it's a free-for-all. So that's when you see generics or other companies sort of coming in, employing similar technology. And there's different types of patents. So depending on the subject matter, it can be a process patent, method, utility, software patent, business patent. There are really creative ways that we can protect different business assets using patents. Patents in terms of IP is probably on the more expensive end. So when you have a great idea or you have a concept, budget, I would say at least $10,000 even for the initial draft. So that's again something to keep in mind. With patents, you have what's called a 12-month grace period in jurisdictions like Canada or the US. So if you have particularly a new concept, a new product, and you want to disclose it. Obviously, we always recommend getting non-disclosure agreements and trying not to do that until you get something on file. But if something has been published, for the sake of you filing it with the Canadian Intellectual Property Office, you do have 12 months to do that from publication. Trade secrets is another interesting one because it's not something that you file for. And I think we hear about these things when you think about the Coca-Cola recipe or even Google's search algorithm. or the New York Times best-selling list, all of these things are protected as trade secrets. So it could be a critical formula, practice, or manufacturing method. And the benefit of a trade secret as compared to a patent is it provides you with indefinite protection. It's not something that you file, it's something that you literally keep a secret, and you have to have internal processes to ensure that it's on an as to need to know basis and that you have a trade secret policy in place. And I mean, if we think about Heinz with their ketchup recipe, again, I use Coca-Cola, they kept it a secret. And it's, think about, this brand has been around since the late 1800s. So whether or not you choose to file for something as a patent, so you have that public disclosure, and eventually, you know, you lose the monopoly, and whether or not you keep it as a trade secret is really a business decision to make. And it's something to consider really at the outset, especially if you have something particularly unique. Trademark. So this is also a term we hear often. A trademark is a distinguishing mark that differentiates your goods and services from others. So most typically we think about a name or a logo. It's the way that you brand your goods to communicate to the public, hey, the goods and services that are being offered in association with this trademark come from a single source. And there's different types of trademarks. We'll get into that a little bit. So there have been recent changes to the law already 3 years ago, so 2019 in Canada. So it's not just a logo or a word. There's a whole slew of other non-traditional trademarks that you're able to file for. And again, depending on the nature of your business, this is something really good to think about at the outset when you invest in your branding. Filing costs for trademarks can be anywhere between $1,500 to $2,000. It really depends, though, on the how many goods and services you really want to include in that trademark application. So trademarks in general, you don't get it. It's not like a patent, where a patent you would get a particular invention and it's across the board. A trademark is specific to the goods and services that are associated with that trademark. So that's why you're able to have Excel gum and Excel the software, and people don't get confused. It's the exact same trademark, but it's in completely different channels of trade. So you have to be very selective when you're filing for your trademarks, or when you're using your trademarks. You have a particular niche, and that's the scope of your protection, and that's what you would include in your application. So why you would file for a trademark registration. So the second you start to use a trademark, you develop rights. It's totally different from patents and industrial designs in that sense. You develop what's called common law rights. However, when you register a trademark, you get better rights. And the best way to describe this is if, for example, you own a restaurant in Quebec, like in the north of Quebec, and it's a great restaurant, and everyone around the neighborhood knows you. And say it's called Red's Diner, something like that. And you have this tremendous reputation in Quebec, but then all of a sudden someone in Vancouver opens up a restaurant called Red's Diner. And then you don't like that, because obviously it's your goodwill, it's your name, you want to be able to stop them. Without a registration, you can only stop that third party within the limited geographic area in which you could prove that you have reputation. So arguably in that scenario, it would only be in Quebec. The second you get a registered trademark, it gives you the presumption of exclusivity across Canada. So it doesn't matter if you're not actually using in British Columbia, because you have an exclusive right throughout Canada by virtue of your registration, you can stop that person. So it's a tremendous, it's if ever you had to go to court and enforce it, it's a lot less expensive to rely on a registered mark than a common law mark. But hopefully none of you guys ever get to that point. And also, as a litigator, having a registered trademark to be able to include in a cease and desist letter usually cuts off the dispute right there. If you can refer and cite your registered trademarks, people don't want to go down that path. It gets expensive, and usually your dispute will settle. So we really, really advise this. You do not, if you don't have the resources to invest in a registration right away, you don't have to worry about a 12-month grace period. Like I said, use it. keep using your trademark, but the second you can, and if it's your mother brand, if it's an important brand, I would say file for it immediately. So I touched upon non-traditional trademarks, and I'll go through this rather quickly, but it's just really to get you guys thinking what other elements of your products or company can actually be trademarked. That noise, the Mac startup that we all recognize, Apple has filed for a trademark for the sound. So we can get sound, trademark sound. And again, it'll be very specific to the type of business you operate. If you're heavily in the online space, if you have an app, if there's a chime or a noise, sound in general plays a critical part in the services that you're offering, you can file for a trademark. Color per se is a new one. So TD, for example, filed for just the color green. It used to be that you could file for a color, but it had to be as applied to a particular thing. So we have a client, for example, that has the color orange as applied to a circular saw blade, or UPS has the color brown as applied to a truck. Now you could just get color in abstract. So if we think about companies like IKEA or Tiffany with their Robin Egg Blue, where a color is so strongly linked to their business, it's something you want to think about. You can get a position trademark. So Starbucks, for example, filed for the position of the circle on the cup. So it's not a trademark for the actual circle design, it's where it is. I think Levi's has something similar with respect to the tag on the back pocket of jeans. Scent, Crayola filed for the scent of their crayons. And I think if we all think about it, we know that smell, it takes us back to our childhood. It's, again, something to think about when you have a product, maximize your brand protection. But another important thing to note is that these trademarks can't be functional. And what I mean by that is you could never get a scent if your product is perfume, because the function of the product is to provide a scent. Crayola, the function is a crayon, it's to draw. So you could get a scent trademark for that. It's the same thing. Stores like Abercrombie has a very overpowering smell when you walk into the store and you recognize it. But the service is retail services. So you would be able to get a trademark for that. Texture of you can get a texture trademark. So Chanel filed for the quilted texture of their handbag, which we all know and recognize. Taste is another one that we have to keep functionality in mind. So if you have like a particular like a gum or a candy and it's minty, you likely wouldn't be able to get a taste trademark because that's the function. And the only example I could think of for something like this would be like stamps or an envelope, anything to lick and seal that its function is not to taste good. Also something like Buckley's, if we think about their branding, taste awful, but it works. Taste is such an important part of their branding, but taste is really irrelevant in terms of the function of the cough syrup that makes you feel better. So again, forward thinking. We have moving images, which can be like a short clip, and holograms. I don't have an example for a hologram yet, but last week I just gave a talk in Thunder Bay about trademarks and IP in virtual realities. So when we think about augmented realities, I think we're going to see a boom in holographic trademark applications. So again, for your branding purposes, think about what else can be a trademark. And the only caveat I would mention is that to get anything that's not a word, not a logo, so in this category of non-traditional trademarks, they're not as easy to get. You need to prove what's called distinctiveness. And usually that looks like at least 5 to 6 years of decent sales to be able to prove to the trademarks office, hey, I've built some reputation, people recognize me. And then you would be eligible to file for this category of non-traditional trademark. Nevertheless, it's good to think about these things day one so you can incorporate and use them as a trademark in your branding until you're ready to file. You can have 3-dimensional shape trademarks. These are some that we probably all recognize, including the minifig. You can get a trademark also for mode of packaging goods, and these also fall into the category of non-traditional trademarks. So for those of you who are sort of at the beginning stages and, you know, we're thinking about choosing a name, or perhaps you're thinking about choosing a name or branding for a subcategory of services or goods that you're offering, there's sort of, there's a spectrum, a weak trademark, a strong trademark. And there's sort of a bit of a business trade-off, if you will, because weak trademarks would be generic terms like Apple if you're selling apples. No one's going to be able to register that trademark because it would be unfair if you get a monopoly over something like Apple. So other Apple traders, for example, couldn't use the word Apple. So that's a no-go. That's a generic term. And then, you know, deeper into the spectrum, we have descriptive terms. So examples could be like the beer store or the athletic club. It's describing the thing that you're doing, and typically these things aren't registrable, but you may be able to get it if you have enough registration. And then you have suggestive trademarks, which could be like Facebook or Burger King. And then arbitrary trademarks are brilliant trademarks. So Apple in association with computers, it's not a made up word, but it's completely random in association with computers. So it's a great trademark. It's a strong one. And then the strongest type of trademark is a coined one. So a completely made up word like Google or Haagen-Dazs, for example. In terms of strength of your trademark and then the scope of protection you would have, the more unique it is and the less likely, you know, anyone else would have the right to use something that sounds like your trademark, the broader your protection and the better the brand. But from a business perspective, sometimes you want a more generic website or domain name, or you want a more generic trademark, if you will, because it will drive traffic. So if you have, for example, if you have a nail salon and it like the sign says Ottawa Nail Salon, versus if you had something that was called Cookies and it was completely arbitrary in association with nails. Someone walking on the street may not know what Cookies is, and obviously you could have a descriptor, but Ottawa Nail Salon may drive traffic a lot easier. And you have to think with your meta tags as well, when people are Googling and searching things, you may not really care about registering a trademark at all, and you just want a name that drives as much traffic as possible, hotels.ca, for example. And the only thing about that is no one can stop you from using that, but it would be very difficult for you to stop someone else from using it. So it, again, depends on long-term prospects for your business. What are your goals? The nature of the trade, the nature of the business. Are you going to have issues with competitors and them trying to pass off your goodwill and your recognition? In which case you may want to gear towards a more unique trademark that you can enforce. Copyright is one we hear about often as well. It protects original works. So it can be a work of art, it could be a literary work, a dramatic work. If you have a logo that is a trademark, the actual design of the logo may be eligible for copyright protection. Copyright is one of those things that the second you put pen to paper and you create something, you as the author, you own the copyright. You can file for copyright registrations. It's less common, but there are benefits. Again, if you're in a very saturated market and you really want to protect your artistic works or your literary works, then if you have a copyright registration, which you actually don't need a lawyer to do, it's about, I think, $400, I believe, is the fee if you go with a lawyer, but I think it's $50, maybe less than $100 if you wanted to file for it yourself. The benefit of having a registration when it comes to something that can be protected with copyright is that if you went to enforce against someone else, they don't have the benefit of saying, hey, I didn't know it was subject to copyright. You take away that defense from them. And again, it's a bit of like an offensive way of thinking, but it costs nothing. And again, depending on the type of your business, if this is, if it's something that competitors may want to steal, then again, if you have a registration, it's pretty scary on the receiving end if you get a cease and desist letter and you cite all these registered goods, and totally worth it as well, if depending on the nature of your business. And I'll just touch briefly, there's something called the technological protection measure. So it's a lock-in key mechanism. So this can be anything from if you're Nintendo and you have like your video games, for example, the code itself is protected under copyright. The visual representation is protected under copyright. So the software that prevents access, or the physical shape of the game cartridge that fits into the device, there's a new law now coming out in Canada that equates online passwords, login credentials like Netflix, etc. Anything that is a lock-in key that protects copyright work, if you can employ that in your business, and again, it depends on the type of business. If someone tries to mess with your technological protection measure, your lock-in key, then you can essentially threaten to sue them for copyright infringement. So it's just thinking at the outset how to protect the assets of your business. Industrial design is another one. You guys may have heard of patent designs in the US. In Canada, we call them industrial designs. So if you want to protect an original shape or configuration, pattern, or ornament, you can file for an industrial design immediately, and it protects the non-functional features. If you have, if you sell water, for example, and a Voss, I think, has a very unique cylindrical shaped bottle. So bottles are not a new thing, but the particular shape of that bottle can be unique. And if you want to protect that shape and have like a 10 to 15-year monopoly over it, that's something you can actually file for immediately. It's one of the most underrated forms of intellectual property. It's not incredibly expensive, but again, depending on what you're doing, it may be incredibly useful for your business model. You have the similar 12-month grace period as well. And the interesting thing about industrial design filings is there's no distinctiveness requirement. So what are all these words that I'm saying? Going back to trademarks, when we were talking about non-traditional trademarks, so that you have this capability to protect the shape of a product or the packaging of a product, you only get those rights if you're able to prove reputation at the trademarks office. You don't need to do that for industrial designs. It's a completely separate set of rights. You could just have a new product, you could have a prototype, not have one sale, and you can file for it immediately. And just want to bring this full circle. So we'll use the iPhone as an example, as a case study. So just think about, and this is a particularly complex product, but it illustrates the point that you can have one product, but Apple, for example, they file for everything. You can have the shape as a trademark. You could have the app names, Siri's voice, like any chimes that you hear. Industrial designs can protect the shape, the icons of the app. Trade secrets, if they have R&D information, software algorithms, copyright. They have copyright in their software, their apps, their wallpaper, anything artistic. And then they have a ton of patents for tactile display, crack-proof glass, et cetera, et cetera. So you're not limited to one form of intellectual property. And again, budget permitting, these are conversations you should have at the outset with an IP lawyer, especially, again, depending on the nature of your business. You really want to be able to maximize your exclusivity. And that's how you build, that's how you get ahead in the market. So just to get you guys thinking, just to give an example of a product that has a ton of IP. And there's something called evergreening. And again, when we're talking about using different types of intellectual property together to prolong your protection and to be really strategic about it. And again, for this to work, you need to think about it at the outset. There's an interplay between industrial design, copyright, and trademark, and they're all great, but each of them with their respective limitations that we talked about. So, and we'll use a three-dimensional article in this case, just to explain, if you're clever enough, how you can really, really secure a long-term monopoly. So again, with trademarks, we said you have to prove reputation in order to protect a shape. But we have industrial designs. However, industrial designs have a limited term of protection. And then for copyright, you can have copyright over a three-dimensional shape, But an exception built into the Copyright Act that essentially if more than 50 of your three-dimensional shape is produced, then it's not infringement for someone to reverse engineer it. Meaning copyright is really contemplated to protect a sculpture or a work of art that's really one of a kind. And the second you're mass producing, let's say your really unique looking water bottle, your copyright rights are a little bit limited, except if that shape is also a trademark. And that's actually built into copyright law. So hopefully I'm not going to lose you guys, and I'm happy to talk about this offline if someone has a particular shape. But again, for illustrative purposes, the game plan would be at the outset, file for your industrial design. And then what you do is, because you have a monopoly for 10 to 15 years, that's your opportunity to build up your unique distinctiveness. And then when your industrial design protection is coming to an end, you can then file for your trademark, because you will be in a position to prove distinctiveness, because you tell the trademarks office, hey, I've been the only one who's been allowed to do this for the past 10 to 15 years. And ultimately, the second you get a shape trademark, if you were to enforce against a third party, you could enforce for copyright protection because you fit into that exception. Now, why would you want to enforce using copyright and not trademarks or industrial design? Again, because copyright is the best and least expensive way to sue someone. So it's, again, hopefully I don't wish litigation on any one of you. And I mean, I'm a litigator. This is what I live every day. And unfortunately, a lot of my clients are those who didn't have let's say a proper strategy, or they come to us late in the game and they didn't think about this at the outset. So again, have the conversation, educate yourselves, and perhaps there's a very clever way to use different types of IP to really, again, maximize your protection. So using your IP. These are also questions I get asked often. Where am I protected? Patents are jurisdictional. So yes, there's like a patent incorporated treaty that we can use, but you're depending on which country you file for, that's where you will be protected. So no, if you file in the US, you won't be protected in Canada and vice versa. So again, you have to think about where your primary markets are. Is the US your main market? Is that where you want to invest if there's only funds for one jurisdiction? Industrial designs, similar. It's jurisdictional. There's an international system, the Hague system, that facilitates filing in different jurisdictions. But if you file something in Canada, your protection is limited to Canada. Copyright is a little bit different because Canada is a signatory to the Berne Convention. So you arguably have copyright rights that you can enforce across jurisdictions. Trade secrets will be multi-jurisdictional, simply because usually the way to ensure this or protect this as against employees or suppliers, whoever you're dealing with in your business, your rights will be secured contractually. And usually, if you have a good lawyer, these rights will be worldwide rights. And then trademarks as well is jurisdictional. So wherever you file or wherever you use, there is also a new international system that again facilitates filing in different jurisdictions. But there's no such thing as an international trademark. It's jurisdiction specific.
When you say jurisdiction, is that a demographic period or is that legal circles? So legal levels? I'm not sure. I was like, so what do you mean by jurisdiction? So there's like.
Sorry, you're on mute. By jurisdiction, I mean country specific. So when you file, so everything is going to be country specific. Does that answer your question? Yeah, okay. Country specific by jurisdiction. This is also a question I get asked frequently is, does incorporating a business name give me trademark rights? And the short answer is no, but it can get confusing because sometimes your trade name or your business name is interchangeable with your trademark. And I think the main takeaway is that when you have a trade name or a business name, it's used to identify the business versus a trademark that's used to identify the goods and services. So Arguably, if you have a business card or letterhead, and you're using a name on top of there and it's internal, or it's when you're distributing again, like when you're dealing with suppliers or anyone else external, if you're using it in a way that identifies the business, that's trade name use. If you're using it to brand, let's say Coca-Cola is a good example, their registered legal name is Coca-Cola Limited. Their trade name, they'll refer to themselves as Coke or Coca-Cola, which is also a trademark. And then the logos, for example, are exclusively trademarks. So we have to think about how you're using it. And then depending on how you're using it will depend on what it is that you have. A trademark, a trade name, registering one doesn't give you rights in the other. Another thing to consider is how you use your trademark. So you don't want to use your trademark as a noun or as a verb. You want to use your trademark as an adjective. So ideally, we would all be saying Google search engine, not I'm going to Google it. We don't want your trademarks to be used in a way that could render them generic, and then you lose your trademark rights. And the funny part about it is that trademarks that fall into this category are killed by their own success. So some of us may not know that zipper was a trademark. It was a brand name. It wasn't, I don't even know what the non-brand name word for zipper is, but they were so successful that people were just calling them zippers. So now it's very difficult for whoever owned zipper to enforce that against anyone, because anyone's allowed to use it. The public is accustomed to using it as a generic term. It's the same thing with nylons, escalator, aspirin, kerosene, yo-yo. These are all once previously they were trademarks, and they were used in a way that rendered them generic. So careful how you use your trademark. Yellow Pages is also a good example as a company that succeeded to maintain their so-called generic trademark because they were heavily policing anyone else using Yellow Pages. So it's just something to keep in mind in terms of how you actually use your trademark. Deviations. This is also something I deal with quite frequently, and these are all old brands that have natural evolutions with their trademark, but it can be also that you're in a position where, after a couple of years into your business, you're like, the branding's not working. I want to change the color. I want to change the logo. I want to, change the font. So what happens to your trademark registration? If you don't use your trademark exactly how it's registered, it's susceptible to being canceled for non-use. If you don't use it, you lose it. So if you're undergoing a major rebrand, we always recommend refiling for your trademark, because you want to have that registration for the logo or brand name in the manner that you are using it. This is why we also recommend filing for the broadest type of trademark. So if you have a word trademark, like we'll use McDonald's as an example, the best type of trademark would just be the word McDonald's, no font, no color, nothing, just standard characters, because that word itself will survive any rebranding. If you decide to use a different font, if you decide to use a different color, it doesn't matter, because your registration is for the word and you're allowed to use it however you want. When you have a logo is also why we recommend filing for it in black and white. Black and white gives you all the colors. So say you have this awesome logo and it's green, and then in a couple of years, green is not working for me, I want to do red. If you had filed for a black and white trademark registration for your logo, you're good to go. So again, sometimes it's inevitable. If there's a complete rebrand, you may want to refile. But again, you're paying money for this. You're paying good money for these registrations. So you want to ensure that you have the broadest form of protection and that it will survive any minor rebrands. Marking and notices. So we all see this on our packaging, on websites, TM, R, C, D. What do these things mean? Can I use them? When can I not use them? A TM you can use next to your trademark, whether or not it's registered. So if anyone has a website branding their logo anywhere, I'd recommend slap a TM on it. Tell the public you're using it as a trademark. You don't need a registration for that. The R in the circle is limited to trademarks that are registered. You cannot put an R in a circle next to a trademark that is not registered. The repercussions are way worse if you operate in the US. It's akin to fraud and no one wants that. C in a circle is associated with copyrights. We often see copyright notices at the bottom of web pages, for example. That's what the C in the circle designates, usually alongside the owner of the copyright and then the year it was published. And then D in a circle, which is less common, signifies registered industrial design. IP due diligence. Again, so this whole talk is about different types of IP and, why you would file for IP, why you shouldn't file for IP, what use does it serve from a business perspective. So in a lot of respects, it gives you exclusivity. So this could mean a competitive edge. It gives you a stronger market position. It may increase investor confidence. So if you're pitching and you're looking to get funding, investors love to see a list of, pending applications or registered marks. They are like intangible assets that are linked to your business. And that's why it would increase valuation of your business. For example, if you have a business model that would enable you to license or cross-license or enter into joint venture agreements, having those secured registrations is also incredibly useful to really define the rights and, to attract licensees. They want people who want to use your mark under license, they want to see the registrations. It gives them confidence in the brand. If you're looking to sell your company, for example, or enter into a joint venture, it gives you tremendous negotiation power. And then if you're into a lot of R&D expenditure, especially in the context of patents, we see big pharma do this a lot. They rush to file their patents because they spend hundreds of millions developing this drug, and they really want to ensure that they have the monopoly and get that return on investment. But just on that, for pharmaceuticals, it's interesting. Viagra is a good example. They invested a lot. Their patent is now since expired. But if we pay attention to their commercials, they are leaning heavily on their trademark. Trust the brand you know. So they may no longer have a monopoly, and others may be able to sell a generic version of it. But because during that monopoly, they have pushed their branding, the little blue pill, Viagra, they still have a market advantage because they have goodwill and reputation, and the public recognizes that brand. So just because you have a patent, it doesn't mean that the trademark aspect isn't important. Branding is just as important. And like I said, trademarks subject to renewals are a right that you keep forever. So again, very important to think about the interplay between these different forms of intellectual property. Okay, so just some general advice. It's important to keep track of your IP. So very important to know what the IP is and who is the owner. And it may sound like an odd question, who is the owner? Of course, I'm the owner, it's my IP. Maybe not. If you're a company that hires contractors, for example, to build your website, to write your content, to create an app for you, for example, the de facto position is that that contractor owns the IP because they're not an employee, unless you have a written agreement that assigns it to you. So you want to make sure, or if you have inventors coming up with something, you want to ensure in their employment agreements that everything gets transferred to the company, depending on whatever ownership structure you want to set up. It's important to keep an up-to-date portfolio. This could be as simple as an Excel spreadsheet, when you filed, your registration numbers, what the IP is, expiration periods. For companies that are growing, a good habit to get into is to really centralize your internal IP management, designate appropriate gatekeepers. So when there are issues or when there are, potential business opportunities, you want to have that one person who's incredibly organized, who's managing the portfolio, dealing with outside counsel if need be. And they should be aware of the big picture. I can't tell you how many huge companies I deal with where we have the branding people and the marketing people, and they're not talking to the R&D people and the patent people. And it's like, well, guys, let's work together and figure out what the best way to protect our assets would be. So whoever this designated person is, let them be the one to speak to an IP practitioner, do the research, understand the big picture, and let them communicate with all different parts of the relevant teams. Being proactive. So obviously, you know, before investing in a particular brand, in a particular product, do your due diligence. There's a difference between registrability and freedom to use in both the patent and trademark sense. So the question of, hey, can I actually file and register a patent or file and register a trademark is one question. And the other question is, if I use this trademark or this technology, am I going to get sued? Does it actually belong to someone else? And when I deal with people who are so excited about their great name that they came up with or the great product, and it basics Google searching reveals that someone else has been in the market in the exact same space for, you know, years before them, it's like, you know what, you may get sued. So you want to do your due diligence to ensure that you have the right to use the thing that you want to use. And then the registrability is another concern. A lot of the resources are free. You can, you know, use the Canadian intellectual property databases, the United States Patent Office, Patent and Trademark Office databases to do some basic searching. Get on Google, see what your competitors are doing, use different keywords. And again, keep in mind the thing that you're doing in association with the particular trademark. So if you sell shoes or clothing, you may look for, you know, other competitors in that space and not someone who's, let's say, doing software, which is completely different. So once you have your IP, you want to safeguard it because it's your intangible assets. You need to police. So monitor marketplace activity, know what your competitors are doing. It's a good habit to get into. Whoever is the IP gatekeeper, get on Google, see what's being used out there. Once a month, are people trying to knock you off on Etsy, on Amazon, on eBay? Are there fraudulent domain names that are popping up? So there's, I am involved in a lot of online takedowns. When you build enough momentum in your brand, is someone filing for a different domain and trying to sell counterfeit goods, for example? Know what is going on around you and make sure you police your trademarks. At this point, you've invested so much into the due diligence, into the filing. You have your portfolio, you're internally organized. Now it's just a question of knowing and making sure that you maintain your exclusivity. And I'll just touch briefly on risk versus reward. I am never going to tell someone to deliberately infringe on someone else's intellectual property. However, there's a lot of gray areas where you won't get a clear answer from an IP practitioner. It may be confusing, it may not be confusing, it may infringe, it may not infringe. Depending on your type of business, you may choose to assume that risk because you'll have short-term tremendous profitability. And usually in intellectual property scenarios or disputes, all the person or the company wants is for you to stop. So again, I'm not encouraging anyone to infringe anyone else's intellectual property, but if you're in that gray zone, the risk may be worth it until you get a cease and desist letter or whatever, or if you disturb the marketplace enough to get noticed, or if you're flying under the radar. It really depends what you're doing. And these are just some examples of brands that are in the gray zone that are maybe, let's say, flying under the radar with respect to copyright and trademarks. If what you're doing is a parody, for example, Canada, US law is a little bit different. There's something called fair use for trademarks in the US. We don't have that concept in Canada. But for copyright, if what you're doing is fair dealing, or it's, again, a parody, it may be okay, even though it's deliberately trying to copy someone else's work. But if the public wouldn't be, let's say, confused into believing one comes from the other and it's clearly a joke, if it's not for commercial purposes, for example, if it's just part of like a not-for-profit ad campaign, etc., again, you're in the gray zone. Alternatively, you can always, try to seek licensing arrangements with these companies. But again, things to consider where perhaps being in the gray zone is worth the risk because there's the potential for, tremendous profits early on. And then I just have a couple of slides left, so it's good timing. So contractual considerations. This is a big part of my practice as well. I've touched upon this. An employee versus a contract in law has very different implications if they're creating content or creating or inventing things. Who owns the IP? Typically under copyright law, if someone is an employee and they're performing their typical duties under their employment agreement, anything they create will belong to the company. It's different in the context of patents. And then with contractors, you always need to have everything in writing. And if it's not a standard provision for intellectual property, you want to get a lawyer to make sure to look at this agreement to make sure it's fair and what you're actually, exactly what you're getting. Non-compete provisions. If you have employees, for example, contractors, you may be able to throw one in there to prevent them from duplicating what they did for you for someone else. Assignments. So if we are in a situation where you have inventors or contractors who inadvertently own your IP, it's not the end of the world. We can just get them to assign it over to the company. But it's always good to think about these things at the outset, because then if you get the disgruntled former employees who don't want to help you or who try to extort you, and it's a key part of your business, it gets messy. So think about these things at the outset and employment agreements. Anytime you enter into a supply agreement, check the IP provisions. Licensing. So if you're in a position where you're able to license your trademark, it's not here you go, you can use it. I don't need to check in on you. Nope. If you want to maintain your trademark rights, you need to maintain care and control of whatever goods and services your licensees are offering using your brand. You have to maintain the integrity of your brand. You have to maintain control. The second you don't maintain control, you're in a position where you can lose your trademark rights, because now you have arguably two players using the same trademark in the marketplace, and you kill your uniqueness, you kill your distinctiveness. So licensing is a great thing. It's a great business opportunity, but be incredibly vigilant. There's not for inventions, anything, trade secrets, non-disclosure agreements, simple boilerplate documents. If you're in a particular business where you're dealing a lot with secretive information, you can have a standard NDA, basically fill in the blank for the person you're dealing with, the services that they're offering you, and then the terms are pretty standard. You can file for provisional applications if you have like, let's say an invention you want to protect, just to get make your line in the sand, like, this is my priority date, I'm first. A provisional patent application is like an incomplete patent application, when you just want to throw something quick and dirty together, get it on file, and then you feel more comfortable, let's say, speaking to investors, because no one can rip you off. You have your filing date secured. So it's something to think about. And again, ask your IP counsel about software developer agreements, privacy policies, terms and conditions, anti-spam, etc. So this is my last slide. So just to talk about exit strategy. So if you're in a position where you've built up your business, you want to sell your business for whatever reason, and then you have this awesome IP portfolio that's been super organized, well kept. Or if you're looking to purchase a business, maybe you're looking to purchase IP, works both ways. Verified chain of title, meaning, are we sure we own what we think we own? Did we need to get the assignments, inventors, employees, etc.? Review current inventory of all IP. Consider the scope of the IP. So you may think that your patent protects the entirety of your product, but more often than not, a patent will protect a particular invention within a product. So know what is actually within the scope of your patent. Know what goods and services you have in association with your trademarks. Consider relevant expiration dates. So if you have 2 years left on a patent versus 15 years, it's going to dictate the value of it. You want to ensure no contractual loose ends. So again, assignments, licensing, etc. Third-party rights. This comes down to if there's potential litigation, if there's due diligence, if you're aware of third parties infringing, if someone has sent you a cease and desist letter that could be potential liability on your end, that's something you need to disclose typically. Consider representations and warranties. And again, if you're unsure, and it's a very complicated area of law, and I really hope I try to make it as accessible as possible, coordinate with IP counsel. We are happy to walk you through it. And that's it. So if you guys have any questions, please let me know. I'm happy to answer.
Hi, great presentation. Thank you, Deborah. I'm a sole proprietor for consulting engineering. I like the idea of maybe doing some IP around the concept of my business. But like, oh yeah, sure, I can get these intellectual rights, but then are there, and you mentioned gatekeepers, but are there like people or a business out there that can monitor and like keep an eye on that? Because yeah, sure, I can do the IP, but I'm not actually going to put any time into, you know, monitoring.
Yeah,
that's
so
happening. So what's that business? Is there a business out there that does that?
So let's say we'll typically do that for clients that request pay for it. So we'll do like watch services for trademarks. A lot of huge companies, let's say they do watch services, and it'll look something like anytime a trademark is filed that it has like a more than 50% chance of being confusing with yours, we get a ping notification, we assess, we look, we'll notify you, hey, do you want to do something? Do you not want to do something? With patents, it's a little bit more complicated because it takes more substantive review, but you can absolutely set that up. It could be like a monthly thing, a quarterly thing that you can set up. With patents as well, what makes it a bit more complicated is that when you file, it's not disclosed for 18 months. We may be able to give you a good idea of what's going on now, but I don't know what was filed 18 months prior. Right. So yeah, it would typically be intellectual property law firms that would set up these watch services for you.
Services. And then, so lots of, like you mentioned, all the filing costs, but do none of these IP formats have like an annual maintenance cost, like, or there's no more investment into that?
Oh no, there is.
Okay,
so
yeah. I was wondering, like, there must be.
Yeah, so those general costs that I put up on the slide, yeah, they're typically just for initial filing. So
yeah, so your fees would be like, okay, if I want your business, this would be about how much it would cost
for the initial filing. But then let's say for any time there's prosecution, so if the intellectual property office hits us back and say, hey, we have a problem with this for this and this then we have to submit arguments and response, so there's a bit of back and forth. Then to make it even more complicated, much more rare, you can have an opposition for trademark. So it's like these are initial filing fees, and then there can be plus. Typically, if everything goes well, it's not astronomical. And then once you have it registered, for patents, you have maintenance fees, which is it's not that much. And for trademarks, it's renewal fees, but that's every 10 years. It's not an unattainable thing. And you're sort of kept in the loop at every step. And if you're at a place where it's like, this is not worth it anymore, there's nothing stopping you from pulling the plug or just, right. I tried and that's it. So yeah, there are additional fees and you're kept in the loop, but it's really hard to provide. I don't know. Obviously, we draft our goods and services and our patent applications in a way that we hope will satisfy the intellectual property office, but there is typically back and forth. Sometimes not. If you have like a great trademark, completely original, it just sails through. It's usually the trademarks that are, maybe confusing with another one, or a trademark that is very descriptive of what you're doing. So we can sort of gauge for those things at the outset, but yeah, it's definitely not just one and done with the filing fees.
Yeah, okay, that's great.
Hi, Deborah. Melissa here. How are you?
I'm good. How are you? Thank you for joining.
Great, thanks. So I am a business growth advisor with Pero, and I have a client. She has a registered business that she's been operating for the past 25 years, and she has recently been approached by a rather large organization who wants to take over the business model. At the moment, they're hiring her as a consultant to transition and run the business model through their organization, but her ultimate goal is to sell it. She's not too sure where she needs to go at this moment. Nothing has been registered, no trademarks, no copyrights, nothing like that. She's not too sure what she needs to do in terms of valuations or anything like that. I'm wondering if you might be able to offer some next step suggestions for her.
Okay, so I would get her ducks in a row in terms of usually for like asset purchase agreements or acquisitions like this. It's a combination between corporate lawyers and IP lawyers working
She's
together.
got the corporate lawyer.
Yeah. So
Okay.
if she has a corporate lawyer already who's familiar with this like purchasing and selling of businesses, that's great. But when it comes to valuation, I think there are independent companies that will, I mean, they spit out a number, but before you get to that point, I would perhaps like get her to really speak to an IP practitioner, make a comprehensive list of what her assets are, because if we don't have any registrations, fine, maybe she can get a trademark app. I don't know if it's branded in a particular way, and then that part of that brand, because it's associated with the business model, is what they want to market and push. I would get a trademark application on file. I would really iron out what the assets are before getting it evaluated or coming up with a price. Like sometimes you don't even need to pay these companies for an evaluation. I was involved in a litigation where we had like two competing companies essentially using the same freaking trademark. And it's like eventually the bigger one wanted to swallow the smaller one, and the smaller one had invested in like getting this so-called business evaluation. And then they're like, yeah, okay, this is the number. And the number is completely like what you're comfortable with. You like, it's your business, it's your baby. So I would create the package that says this is why it's this valuable, and then come up with a reasonable number in discussion with your lawyers. And like everyone has a price, right? It's not $100, but it's not $2 million. So it's like, I think that's what she really needs to think about and outline the value. And you can hire this company to give you a valuation, but it's unless it's incredibly specialized. Like for example, my husband's a lawyer. He does dental transactions, buying and selling dental practices. It's such a specific niche, and it's a formula at that point. How many hygienists, how many that. Typically, businesses, it's difficult to put a clear number on a transaction. It really comes down to how useful it's going to be for this bigger company. So I would just say, speak to the lawyers, come up with the list, think about what her number is.
Okay, because her lawyer did mention something about her business model being her intellectual property, and that would have a value associated with it. So she's just not too sure if she can come up with that number, right? To say, this is why I feel that it's valued at this much, because it has this much impact on our community, you know, et cetera, et cetera. The business model itself is not unique by any means, but it's very effective. So I can see how this organization wants to adopt the business model and how they can grow within Northern Ontario. So do we take in those considerations as well in terms of what their plans are for taking that model?
There must be precedents, like other examples of similar situations and kind of like market surveying, right? Like,
there is, but it's so specific. But the thing, I think IP is one part of it, but she has the infrastructure. Companies just want to like buy something that's neat and clean and I can expand. They don't want to create it from scratch. So it's like, that's the main thing. I have an established business, I have an established model. You've been hiring me to do this as a contractor and you want to acquire it, no problem. I'll do, and then she can even like, we can talk about this off camera, but it's like, she can even negotiate, like if she wants to stay on as a consultant or as an employee. So if she wants to take less for her business, but arrange a contractual agreement between herself and get income for the transition.
Yeah, that's what she's doing right now. She's initiated that contractual transition where she's going in, she's training them on how to do the model and how to do this business. But her goal is to ultimately sell so that she can reinvest it into a new business opportunity.
Wow.
Yeah.
Good for her.
Yeah, it's amazing. She's been doing this for 25 years. So we're all very excited.
She should think about licensing.
Yeah.
Licenses it. She maintains her rights. The company uses it, can use it. And then she, depending on what the company wants to agree to, she can go ahead and license her business model.
Yeah, she can sell it to other organizations.
Yeah. Well, the organization that's interested in purchasing is very reputable. And they will do really great and amazing things with it. She just wants to make sure that she's being compensated fairly for everything that she's put into it, right? So that's amazing. I might be sending you a separate email. Thank you so much, Deborah. Appreciate your time.
Were there any other questions, guys?
Okay, can I get a copy of the presentation to email? And can I bother you sometimes if I have questions?
Yeah. I think, can I share this? Yeah, I can flip you this. Or I think it's available through Paro. I think the actual recording and everything will be available anyway. So you'll have everything, and you'll even have my speech.
Exactly. So thank you so much, Deborah, for this wonderful information. I even learned a lot, surprisingly, for sure. There's always an opportunity to learn, so thank you. I'm gonna stop the recording and we'll continue if you have any other discussion points, definitely, so thank you. And for those who are watching recording, there is these details online for Deborah. I'm sure you can contact her at any time with your personal questions for your business. So
absolutely, we welcome them. You can call me, email me, we'll have a nice chat.
Fabulous. Have a beautiful day.
Thanks, everyone.